Good morning. May it please the court, my name is Davis Frye, and I represent the appellant Brandon Nursing and Rehabilitation Center. We are here today asking the court to apply a strict interpretation to Mississippi's version of the Uniform Healthcare Decisions Act. This case focuses on Section 211 of the Act. In the lower court, this judge, our trial judge, created a new obligation on healthcare providers. The trial judge interpreted the act to require healthcare providers to conduct research, ask questions about a patient's family, look into the relationship between the patient and their family, and actively, affirmatively disqualify family members from serving as surrogates before the family member who's there in person with a patient is allowed to be a surrogate.
Counsel, it does seem to me there's some ambiguity in the statute. It uses the word priority, then lists a variety of relatives, and a brother is not the first relative who is alive for Mr. Stanford. There's also nothing in the statute that creates some sort of obligation on the medical facility to try to run down other people, but isn't it somewhat ambiguous what to make of the word priority? And then this surrogate is not high on the priority list.
Your Honor, we believe the statute not to be ambiguous. The 5 words in descending order of priority is intended to simply reflect the realities of family relationships in America. Is
there any evidence that Mr. Phillips, as subsection 4, I think, of this 211, requires actually contacted other relatives, put them on notice I'm acting as surrogate?
Your Honor, we do not have evidence that he actually contacted other family members, but I'm glad you raised that provision of the statute, because applying it as the appellee asked you to do would eliminate and render meaningless that provision. The duty is on the surrogate, the person who has accepted that role. The duty is on the surrogate to contact all the family members listed in Section 211.2. That's a duty on the surrogate. And the purpose of that duty is to allow all of the family to know that they've taken on that responsibility or that role, and to be involved and engage in any healthcare decision that may be needed for the incapacitated patient. So that section puts the duty on the surrogate, not the healthcare provider, to notify other family members who would otherwise qualify as a surrogate under the Act.
You mentioned in starting, this is the Mississippi Uniform Healthcare Decision Act, Uniform Law Commission Act, which has comments. Has that been pursued at all? Are there any comments under the Commission's draft of this law, and what is the law in Mississippi on whether we could use those?
So, Your Honor, it was adopted by 7 states in the U.S., this Uniform Healthcare Decisions Act. And there are notes in the comment section by the Uniform Law Commission. None of them interpret those 5 words in descending order of priority as requiring some affirmative conduct by healthcare providers to disqualify family members. The intent of the Act is to encourage access to care, to facilitate care for residents or patients who are incapacitated.
Counsel, I'm very confused because there are multiple provisions of this statute that in fact require your clients to disqualify family members. So, for example, if there is a disagreement between members of a class, the statute affirmatively empowers and obligates you to disqualify those members of the class and everybody inferior to them in the order of priority. So the idea that you don't have that obligation seems inconsistent with at least that provision. And I don't understand how you seem to be reading out Section 4141.219(1)B, which specifically gives your client an immunity for declining to follow the decisions of a surrogate that lacks capacity. I mean, that seems to suggest that you both have an obligation to understand the capacity of the surrogate to make the decision, and it empowers you, gives you an immunity from a pretty broad immunity if you determine in your independent judgment that that surrogate lacks the capacity to make the decisions on behalf of the patient.
That's right. That is a safe harbor that is built into the statute that would protect decisions made by individuals who are not otherwise fit to serve as a surrogate. So that safe harbor, though, doesn't change the true preconditions under Section 211, which are stated specifically, one, that the individual lacks capacity, that a primary care physician has determined that a patient lacks capacity, and two, that no agent has previously been designated to serve as a surrogate.
And if an agent is designated, so let's walk through a couple of the provisions. So Section 205, Section 209, right? Section 205, that's a procedure for powers of attorney. Section 209, that's the procedure for advanced healthcare directives, which can also be made by agents and surrogates and guardians. You have an obligation, don't you, to make sure that those documents are executed correctly? There's all kinds of reticulated requirements about witnesses and blood relatives and who owns a healthcare facility and who's got to write the will. You have to check those, yes?
Well, certainly we have to.
Is that more burdensome on your client to make those checks than it would be to call, for example, the adult son of your patient?
So I don't believe so, no. I believe when a patient comes in, and again, the purpose of the act is to facilitate care. When a patient comes in, you can ask, first of all, do they have capacity or not? Secondly, is there a POA? That is built into our healthcare system. If there is a POA or a healthcare surrogate already named, then we know that's the right person to make decisions.
Do you have to look at the POA? So say there's a power of attorney. Does someone at Brandon have to go through that document and make sure that it was executed correctly in accordance with the Mississippi statute?
Potentially, yes, they would.
Surely, right? I mean, it would be crazy to say that you wouldn't. I mean, these are life and death sorts of decisions.
That's right.
And they're pretty complicated procedures for having, one would expect, right, that power of attorney to be. You're foregoing life and death decisions and giving them to some other person. I would hope that the long-term facility is going to check those.
Sure.
And that's got to be pretty cumbersome, right? Presumably there's a lawyer involved, and we got to make sure that, what if it doesn't say in there, I declare under penalty of perjury that I'm not related by blood to the patient? Someone's got to check that.
Right.
And that's harder than calling the brother?
Well, it's not.
Or the son, sorry?
It's not necessarily harder. It's already built in the act. The trial judge and the appellee are trying to create an obligation that's not stated in the act. We're looking at the strict language of the statute.
I hear you, and I want to understand that, but the thing, so much of your position in this case, and your friend, the amicus that participated, is, oh my gosh, Judge, this is crazy. This is going to be so hard for us. It's going to impose these crazy obligations on us that we can't do.
I agree, Judge.
And I'm trying to understand how those obligations of picking up the phone and calling the adult son are somehow more difficult than what the statute already places on you.
Think about a scenario that is pretty typical. Let's say two brothers leave to go turkey hunting early one morning. While they're driving to their land, one of the brothers has a cardiac event and needs emergent care. The brother drives him to the emergency room. He arrives, he needs emergent cardiac intervention. The administrator of the emergency department says, I'm so glad you're here. Is he married? Oh, I'm sorry to hear that he and his wife recently separated. Is it a trial separation, or are they legally separated? Does he have any children? Oh, the children live on the West Coast. It's 3:00 a.m. on the West Coast. What are their names and phone numbers? I need to contact all of them. Does he have a parent? Oh, the parent is in an assisted living facility. Does the parent have capacity? I'll need the parent's phone number too. It's not practical. The purpose of the act is to promote access to care.
But counsel, respectfully, all of this seems like a red herring because the statute specifically says readily available. So in an emergent situation, you have somebody in the emergency room, you've got somebody who's turkey hunting, you've got somebody bleeding out on an OR table. Like, I hear you, I get it, right? But that is not what we're talking about, right? What we're talking about is you have a form where you specifically know that there is, in fact, somebody with priority, right? Because you know about the existence of the adult son, you have the phone number of the adult son, and we're making long-term decisions for an incapacitated patient. We're not talking about like, oh my gosh, suture it now or we're going to lose the patient. These are different sorts of things, and the statute contemplates a specific provision for you, which is, okay, fine, maybe you can pick anybody you want when it's readily available, when they're not readily available because we're sitting there in the ER, right?
Well, that's right. So that is the point of the statute, is there may be multiple people, all of whom are qualified under the act to serve as a surrogate. All the family members who are present with a patient can serve as a surrogate so long as a physician has determined that they lack capacity and no agent has been previously designated. So it's okay that there are multiple family members, all of whom can act as a surrogate. Adult children, siblings, brothers, they can all serve as a surrogate. However, there is a natural order of priority that reflects the realities of family relationships. The purpose of the act is to ensure that an individual's personal preferences regarding health care are satisfied and honored. And it's natural that a person's spouse is likely to be in the best position to know what their personal values are and their personal health care preferences. Secondly, an adult child. Next, the parent, then the sibling. So the priority makes perfect sense that it's intended to ensure that the individual patient who is incapacitated, that their wishes are honored. That doesn't create this additional requirement for healthcare providers. It's not stated in the act to get on the phone, search Facebook, try to determine if there are other family members, try to figure out family dynamics. Instead, the duty is on the surrogate, the person there with the patient at the provider, to notify all members of the class. If you look at section...
All right, let me ask you, it seems to me, I know you had more to say, you don't have a lot of time left though, so I'm sorry for the interruption. One of the things that strikes me as a little odd in this statute, I think the scheme as you understand it on behalf of your client, is that somebody like the brother can come in, something needs to be done right now, the medical facility admits the person, does whatever needs to be done at that stage, and it's upon that surrogate, who may not be the highest person on the priority list, then contact everybody else. And if there's some problem, there's a higher level priority person who doesn't like the brother acting. That person can come in, can disqualify anybody. It's kind of an odd provision, can disqualify a surrogate. But I don't see it set out in the statute, what would have been a fairly simple thing to say, that if a surrogate is chosen who is not the highest priority, someone with the higher priority, instead what this can come in and take that place. Instead, what the statute talks about is if somebody at the same priority level, group of people, disagree and it's tied, then the medical facility does not accept anybody's view and can't accept the decision of anybody lower on the priority list. I just find the piece missing, and one way to take care of that missing piece is to say priority matters, and it is upon the medical facility, nursing home, or retirement facility, whatever it is in this case, to try to find the highest priority person from the beginning, because there's nothing in the statute that really deals with you not having done that.
And my response to that, Your Honor, would be that I believe it's not set out in the statute because it's clear what in descending order of priority means. The Uniform Healthcare Decisions Act was drafted over 30 years ago, adopted by 7 different states. No published decision we could locate has interpreted the act to place an affirmative burden on a healthcare provider to disqualify surrogates. The intent is to facilitate care and ensure that people get care. It's not some legal requirement to disqualify a spouse in favor of a sibling. That would be an impediment to a person receiving care.
Well, since it's not in the brief, I take it you also didn't find any case from those other states that supported your point of view.
Very wise of you, Judge. That is correct. We didn't.
It's just an easy guess.
But what we did find were cases who went through the elements when looking at a surrogate. Cases that said, okay, the primary care physician determined a patient lacked capacity. No agent was identified. Who is it acting as a surrogate? Oh, it's the daughter. She qualifies because she's one of the enumerated class members in the family. Or a sibling. The cases that we did find in Mississippi and in other jurisdictions simply state and confirm that the patient or the surrogate is in fact someone who falls within one of the enumerated categories of family. Never was there any inquiry, well, did a spouse exist? Did an adult child exist? Did a parent exist? Instead, they just looked to see that the surrogate fell in one of those enumerated categories.
Let me ask you, is there something in the statute, I haven't heard it yet, that you think clearly, explicitly tells us what to do? Or is it more how you're reading the overall operation of the statute?
It is taking the statute as a whole and applying a strict interpretation to the language itself.
All right, thank you, Counsel.
Thank you very much.
Good morning, Your Honors. May it please the Court. Paul Williams on behalf of the appellee. As the Court is aware, the only issue is whether legal capacity existed for Russell Phillips, the brother of an incapacitated resident, Mr. Mark Stanford, possessed authority as a statutory health care surrogate under Mississippi Code annotated 4141-211 to bind his brother to arbitration in this matter. In enforcing the Mississippi Healthcare Decisions Act according to its plain language, the district court correctly held that Russell Phillips did not qualify as an appropriate healthcare surrogate for Mr. Stanford and thus was not capable of binding him to arbitration. As the court is aware, at the heart of the dispute in this case is the priority language within that healthcare surrogate statute. The language of subsection 2 provides a clear hierarchy as to who may serve as a default healthcare surrogate in the absence of an appointment of a surrogate or where an appointed surrogate is not reasonably available. The 4 enumerated classes within subsection 2 include spouse, then adult child, then parent, then adult brother or sister. The appointment of surrogacy documentation that the facility utilized in appointing the brother as surrogate for Mr. Stanford utilized this exact priority language, referenced the priority language, and while there was I guess a mischeck on the documentation itself as to what Mr. Phillips' relationship actually was to Mr. Stanford, they checked they checked adult child, which would have greater priority than brother, but Mr. Phillips was obviously the brother of Mr. Stanford. The statute...
Anything in the record explaining that check mark?
There is nothing in the record that explains the check mark.
Anything in the briefing?
In this clear hierarchy, well, let me move that in 2008, Mississippi Supreme Court returned to a strict interpretation standard with regard to the Mississippi Healthcare Surrogate or Mississippi Healthcare Decisions Act. This act was, I believe, adopted in 1998 by the Mississippi Legislature, and it was based upon the Uniform Healthcare Decisions Act that was approved in 1993 by the National Conference of Commissioners on Uniform State Laws. While the Mississippi Healthcare Surrogate Statute does not have any comments accompanying it within the statutory scheme, the Uniform Healthcare Decision Act of 1993 does contain comments that do give some insight into the intent of the certain provisions.
Is any of this in the briefing?
There's reference to the act, but that is not in the briefing.
And I was wondering why I wasn't there. It does seem to me raising new arguments and new authority here at oral argument. Is that a fair assessment? And which is fine. I'm willing to hear it, but I just want to make sure that this has not been
It has not been.
presented in briefing, an opportunity for the other side to respond to it. But we'll see where this goes.
Well, Your Honor, in those comments, it references, I think, gives some insight into a couple of provisions within the statute. First is the notification provision. One of the arguments that has been made by appellants in this case is that the notification provision provides some guidance on that it is the purpose of this notification is for other family members who may have greater priority than a lower family member in priority who has assumed authority to usurp that authority based on their status within those classes. That is not the purpose of the notification. I think that there's 2 primary reasons that is not the purpose of that notification statute. And the first would be that the notification provision would apply to even someone with the greatest priority. So if the purpose of the notification statute is to allow someone else within that hierarchy of individuals in subsection 2 to notify someone else to who may have greater priority, then why would the top priority also have that same obligation? Because someone with lower priority would not be able to usurp that authority. I think even more importantly is that in that comment, it makes reference to the fact that the notice provision within this statute enables family members who are within those classes or who are close family members of an incapacitated individual. The comment states that the notice provision will allow them to be able to follow healthcare developments with respect to their now incapacitated relative. The purpose nowhere in the Mississippi statute and nowhere within the Uniform Statute 1993 does it indicate that this notice provision is somehow a basis for placing other family members on notice of an obligation to assert a greater authority than the individual who has accepted that.
Mr. Williams, I don't know if that's a completely fair assessment of the comment. The first sentence of the comment, notice requires a surrogate to notify members of the family member who in given of the patient's family, who in a given circumstance would be eligible to serve as surrogates. There's at least an implication potentially there. You're telling the other potential surrogates. It doesn't say what they then can do, but the statute itself says what they then can do. And then insofar as what the other purposes are, notice will enable them to follow healthcare developments. It will also alert them to take appropriate action, which could be to try to displace the person, or the example given after appropriate action is what you said, or maybe you didn't read it out loud, I don't remember, including the appointment of a guardian or starting judicial proceedings. So it at least seems implied there in the comments that you're letting the other potential surrogates know and they can take appropriate action. And again, let me ask you before we go any further with this, did you find any case law that says Mississippi, which did not adopt the comments as a part, like you might with the UCC or something else, adopt the comments? So some states have done that. Has Mississippi said anything generically, at least, about whether they would look at comments from a uniform law?
I have not found any case law that indicates that, Your Honor.
Well, we need to apply general statutory interpretation principles of the state in which the act exists, so it would be relevant.
That's right. Your Honor, I think a couple of things that are important as well that have been noted by the appellant in this case is there's been multiple reference to the intent of the statute being to facilitate care. I think that is true, but I think the purpose of the statute goes further than being simply to facilitate care. And I think that is to facilitate care that is most consistent with the incapacitated patient's desires or wishes, which I think is the purpose of the priority within the statute to begin with. The closest individuals to that incapacitated resident are going to have more knowledge about the personal autonomy of the now incapacitated resident and the decisions that they would desire to make.
Is there anything in the record for Judge Wingate before us as to when other family members did become aware of Mr. Phillips acting as surrogate, whether they were at all involved in health care decisions thereafter, at least insofar as Brandon facility is concerned? What do we have on that?
There is nothing in the record that indicates that they were ever made aware of Mr. Phillips' signature of the acceptance of the facility's appointment of surrogacy in the case. So there is no indication as to when or if they ever even were made aware.
Who is the moving party in this case, a nephew?
Nephew. This is a nephew of Mr. Phillips, is the court-appointed conservator and guardian of...
And what is the role of the son in this litigation?
The role... I'm sorry, Your Honor.
What's the role of the higher surrogate, the son, in this dispute?
There is no... He has no role as it relates to the case that has been filed. Neither does Mr. Phillips. It is the nephew who has assumed that conservatorship, guardianship authority on behalf of Mr. Stanford.
Proceed. Proceed.
Sorry, thank you. Your Honor, I think that it is important to also point out that I believe that there appears to be some confusion in both the amicus brief and the appellant's argument as to the differentiation between the classes of individuals identified in the priority section of subsection 2 versus members of those classes. There is reference to how to resolve disputes, as the court pointed out earlier, amongst multiple members of a same class, but there is no provision contained within the statute about how to resolve disputes among members or of the classes themselves. And I think it is because the plain language of the statute identifies this level of priority. And so where there is a language in the statute on how to deal with disputes amongst members of those classes, the classes themselves are set forth in priority in subsection 2. There,
When you make a subsection 8, an individual at any time may disqualify another, including a member of the individual's family, from acting as the individual's surrogate. That seems to suggest that even if the son had been the surrogate from the beginning, the brother could have disqualified him without any stated reasons. Do you interpret it that way, and how does that affect your argument? Insofar as it's up on the medical facility to decide it's the highest one first, when there's this later lack of dominance by the higher priority, and unless a person can remove them.
Your Honor, the way I interpret that provision within the statute would be that there is a provision there to disqualify a proper healthcare surrogate, and that
Disqualify what?
a proper healthcare surrogate. If the surrogate itself, if the surrogate who has been appointed by the facility is not proper, then there would be no reason for anyone to disqualify that surrogate, because that surrogate's not a proper surrogate to begin with. There is no requirement, and the briefing and the argument of the appellant adds that disqualification language from subsection 8 into subsection 2. They repeatedly argue that absent a disqualification, these individuals can act.
Would you accept that a reading of subsection 8 is if the son had been the surrogate from the beginning, the brother could have disqualified him?
I think it would allow the brother to put the health care provider on notice that he is disqualifying the son from acting.
Could subsection 8 be read to provide that the patient could disqualify the surrogate? It says the individual at any time may disqualify another who's acting as the individual's surrogate. So would that refer here to Mr. Stanford, perhaps?
Perhaps, Your Honor, it could. I think that ultimately that provision would apply to another member within the classes of the enumerated classes, because at the end of the day, when we get to this point in the statute, Mr. Stanford would have already had to have been determined to lack legal capacity to make those decisions for himself. So I'm not certain that it would apply to him directly because of his inability to make those healthcare decisions.
But could the provision be intended to apply to the person needing a surrogate as opposed to another surrogate? In other words, it doesn't say one surrogate can disqualify another.
That is correct, Your Honor. And I think it could. Ultimately, the way that this disqualification section is interpreted, or the way that I interpret it, is simply that if there is an individual, whether or not they are in a enumerated class or have special care, have shown special care concern for the patient, but that they can, if in the event they feel like the best wishes of this individual are not being taken care of, they can move to disqualify someone acting as surrogate from making those decisions. The examples that have been utilized in the briefing and in the argument, the somewhat shocking examples of emergent need of healthcare decisions being made, and this having some impact or severe burden on healthcare facilities in finding someone to make healthcare decisions for an incapacitated individual, I think are alleviated by the act itself. And that is specifically the definition in section 4141-203 that defines reasonably available. The statute itself defines reasonably available, meaning readily able to be contacted without undue effort and willing and able to act in a timely manner, considering the urgency of the patient's healthcare needs. So I think there's three important parts there. One is we have an individual who is readily able to be contacted. The facility knew who Mr. Stanford's son was. They identified Mark Sanderson as his son on the front page in the face sheet of the chart, along with his phone number and his address. He was clearly readily able to be contacted. The next important portion of this definition is without undue effort. I think that it's important, looking at that it says undue effort, indicating that some effort is required on part of the healthcare provider to make a determination as to the reasonable availability of individuals identified within subsection 2. And then then willing and able to act in a timely manner considering the urgency of the patient's healthcare needs. I am not arguing before this court today that there are not going to be some circumstances where maybe a brother can make a decision for an incapacitated resident, because the urgency of that healthcare decision is going to dictate to some degree whether or not higher priority relatives are reasonably available. The issue in this case is an arbitration agreement. There's certainly no urgency in having an immediate signature upon an arbitration provision. Had this been the example that the counsel opposite used earlier, where a decision has to be made on right then, right there within the hospital on a life-saving decision, maybe reasonably available has a different definition, or the same definition is just applied differently. And that is, it is a life-saving or life-threatening issue that a decision needs to be made immediately. Certainly not the case here.
I believe it's only referenced in the briefing. Is there any evidence in the record of Mr. Sanderson, the son's involvement in Mr. Stanford's health care before?
The only evidence within the record are references to his presence at the facility on occasion, that there are occasions where he came to the facility, took his father out, they went on leave from the facility together. His contact information being within the facilities on documentation from the time of admission to the facility. I don't think that there's any indication within the record other than his presence on occasions similar to that of Mr. Phillips during the residency period.
Didn't the briefing indicate that it was the brother, Mr. Phillips, who had been making healthcare decisions for several years, and Mr. Stanford had been in and out of the hospital? And so if the brother has been acting as a surrogate for some time, how does that factor into the equation?
Your Honor, I do not believe that there is anything within the record that would establish that he had been acting as a surrogate for any period of time, that there is indication that he was involved in his brother's life, but there's no indication that he had been making health care decisions for his brother within the record before this court or the district court. Ultimately, Mississippi's legislature created a framework that protects the citizens of the state and assures that medical decisions are made according to each individual's desires and best interest. And given the importance of healthcare decisions, healthcare providers should make sure that they are taking direction only from those with the authority to give it. The plain language of 4141-211 subsection 2 dictates that the existence of a reasonably available member of a class with higher priority supersedes the statutory authority of a member of a class with lower priority to act as a patient surrogate. Thus, if Mark Sanderson, Mr. Stanford's son, was reasonably available, which the record undisputedly demonstrates he was, Russell Phillips did not have statutory authority to act as Mr. Stanford's surrogate, and such was the conclusion of the district court. Therefore, the appellee respectfully requests that this court affirm the district court's denial of the motion to compel arbitration.
All right, Counsel.
Thank you.
May it please the court. To take the appellee's view of this statute, if you read section 211, focused on section 3, which says if none of the individuals eligible to act as a surrogate under subsection 2 is reasonably available, an adult who exhibits special care and concern for the patient and who is reasonably available may act as a surrogate. To interpret it the way the appellee asked and the trial judge did, it would simply make no sense, because an individual who has exhibited special care and concern would just be E on section 2. Because if, as the judge has applied it, the trial judge, you first look to the spouse, and only if the spouse is not reasonably available or somehow disqualified, then you move to an adult child, etc., until you get to someone who has exhibited special care. So again, the interpretation is not consistent with the way this statute was drafted. Mr. Stanford's son was the second responsible party, or the backup at Brandon. The evidence shows that Mr. Phillips, his brother, was the responsible party, the primary responsible party.
What do you mean by that? In documentation that Brandon has, the son was mentioned and he's called. If you can't reach Phillips, call Sanderson, or how does it play out in the document?
So the documentation only shows that his son did appear at the nursing home from time to time.
Right.
So his son was aware that he had been admitted there, but there's no documentation in the evidence that he was ever called for any healthcare decision.
Well, but I thought I probably misled you. You were talking about he was, it seems to me, the subordinate or backup or something, surrogate. Are you saying in some formal way?
No, it's not statutory as a surrogate. Now, certainly the son was eligible to be a surrogate, but he was not statutorily a backup surrogate. Instead, he had eligibility, and the son never disagreed or exerted or attempted to make any healthcare decision in this record that we could find for his father. In fact, the surrogate, Mr. Stanford's brother, signed scores of documents at the time that Mr. Stanford was admitted to Brandon, and again when he left for the hospital and returned to Brandon. There were multiple documents: the admission agreement, Medicare documents, Medicaid documents, numerous contracts that he signed. And there's only one contract in this case that the appellee and the plaintiff is trying to say that the surrogate was not qualified to sign, and that is the arbitration agreement, which under the Federal Arbitration Act must be treated the same as any other contract. Mr. Stanford's son was eligible and could serve as a surrogate if he wanted to. And if he had disagreed with the course of treatment or care of Mr. Stanford, the sons would have priority, and his decision would rule the day. But he never did so. He never exerted that authority. He never made any decisions for his father that we could find in this record.
How many times was Mr. Stanford discharged, if that's the right word, for your client's departure from your client's residence, and readmitted before he was injured? Multiple times?
That I know of, Your Honor, one time. He left for the hospital and was technically discharged and returned. There were other
Is that
times.
when he was injured, the second?
The second time. So he was
Now,
there.
what was the distance in time between those two?
It was a significant period of time, maybe 18 months to 2 years.
Okay. Was there a second documentation like this signed? We're only looking at the initial one, correct? And
Actually, this is the second.
This is the
This is the second. Yes, sir. Yes, sir. I just want to say, too, before I conclude, that if this legislature had intended that the statute be read the way the trial judge has interpreted it, they could have simply said in subsection 2 that any person may, including the spouse, unless the spouse is not reasonably available, then an adult child, unless not reasonably available, then. It could have specified this priority as disqualifying one as you go to the next, but it did not do so. Instead, the statute reads that any member may act. Any member may. We would ask that the court overturn the decision of the trial judge and enforce this arbitration agreement, which was signed by the statutory supervisor, Mr. Stanford.
All right.
Thank you very much.
Both for your assistance to us in this case. We will take it under advisement. And we are in recess until tomorrow at 9 a.m.